Hello, everyone. One of the things that I have been asked before is, what do your school or institution have to do legally for accommodations? Now, I am not an expert in this area at all, but I used to do it, so I can answer them. But for the sake of these videos, I brought in an absolute expert. So if you haven't watched the previous videos where we talked to Dr. Mahadio Sukai, the first set of videos talk about his experiences being a low vision scientist and his career. And now we're diving into his absolute field of expertise, which most people refer to as DEI. Mahadio calls it IDEA, so that's what we're going to call it from now on. So Mahadio, the first question for you is, what does a university institution have to do legally for accommodations?
So Kate, I'm gonna ask you a return question. For whom? Are we talking about students? Are we talking about postdocs? Are we talking about employees? Because the answer is actually different in each of those cases.
Well, that's rather worrying. Okay, can we do all three?
We can. So let's actually take the student case first, and then the employee case second, and then the postdoc case third, because the postdoc case, unfortunately, is the most complicated of the three. So fundamentally, and I'm going to define some terms here. Fundamentally, when we're talking about this word accommodation, we do not mean overnight stays in a hotel, which I think deserves to be said, because I've heard the term be misunderstood in that way, even though it was intended to be used in the context of accessibility related or disability related accommodation. So it does not mean overnight stays in a hotel. What it means is the modification of an environment or a policy, the introduction of a support system that that facilitates equitable participation of a person with a disability in the doing of the thing in question, right? Now, the rules are different if you are a student versus if you're an employee in terms of how things are intended to be done. The principles are basically the same, and the principles go something like this. So there's a series in North America. There's a series of human rights codes and legislation that are intended to foster equitable participation of persons with disabilities in, again, school or work or whatever. And so the way that this works for a student is mechanistically, if you're an undergraduate student or a graduate student, at your school, there is an office of persons with disabilities, or for persons with disabilities, who will provide these supports, and they are intended to be guaranteed under the notion of equitable participation in education, right? And so if you are a student and you actually identify that you require these kinds of accessibility supports, I don't use the term accommodation, again, because it's so easily misconstruable. And it's a little bit of a bugbear of mine that it is so easily misconstruable. So you'll hear me call it accessibility supports all the time. So the obligation of the university is to provide the accessibility support to the student, but only when the student asks for it, right? And so the student has to declare. There's a mechanism for that declaration that is held by that Office of Disability Issues, or that Student Disability Office, whatever it's called on campus. And that mechanism of declaration usually involves some level of documentation of what's called sort of a functional need. And so the functional need isn't necessarily a diagnosis. It is intended to be a declaration of, here's the function that I require an accessibility support for. It's not, hey, I'm blind, I need large print. It's, hey, I need large print because if I don't have large print, I can't write the exam, right? And there's a nuance and a difference between those two things. That the problem tends to be that the way that the process is set up, when I say, okay, I need large print in order to write the exam, then the piece of paper that justifies that actually starts with Mahadio is blind. So so then, you know, we get to this point where we've conflated sort of that diagnosis with the idea of the functional need. And so the obligation of the school on behalf of the student is to review that documentation, and adopt a philosophy where the student should not have any barriers to the completion of their education, and those barriers are removed by the provision of accessibility supports, right? So that works at the undergraduate level, that works at the graduate level. And we can, if you want, Kate, get into the nuances around the difference between how it works at the undergraduate level and how it works at the graduate level, because there are many nuances, and they don't always work the same way. But that's the basic premise behind the accommodation process for students. The accommodation process for employees operates in a manner that is principally the same but structurally quite different. And here the employer, the institution as an employer, actually has slightly more leeway to say no, right? And so if you are an employee, so Kate, you're my boss, right?
Excellent.
And we have a conversation after I've been hired where I say to you, Kate, I need large print in order for me to do my job, right? I've just done something called duty to inform. I've told you of my functional need. You, as my employer, on behalf of the organization, can do one of two things. You can refer me to HR and say it's HR's remit to have this conversation, go talk to them, right? Or you can say, all right, let's actually try to figure this out. And the way that you figure it out is by asking a lot of questions to understand why I need what I need and whether what I need is actually going to help me do my job, right? And so the principle behind sort of that notion of identifying an accessibility support and putting yourself in the space where you're going to be asked for documentation is sort of the same up until that point. Again, the mechanism is different because in the context of education, right, everything goes through the sort of student's disability office, and the question is related to the provision of accessibility supports in the achievement of bona fide academic requirements, right? Learning outcomes, learning objectives, right? But in the context of employment, what we're actually talking about is bona fide occupational requirements, which are structured differently. They're not learning objectives. They're essential things that you need to do in order to be able to do your job. So now when you, as my employer, and on behalf of my employer, have gone through this duty to inform process, then you gather information. At any point, I can actually say to you, I'm sorry, Kate, I don't feel comfortable answering your questions. I've given you all the documentation. I'm comfortable giving you, you're asking things, and I'm really sorry it's making me uncomfortable. I don't want to give you that information. In answer to that, you can say, okay, fine, maybe I don't actually need that information. Or you can say, okay, fine, but in the absence of that information, I can't provide you your accessibility support. Right? And so the obligation of the employer is to ensure that the person with disabilities can do the job that's actually in their job description with those accessibility supports that you're providing. And if you cannot guarantee that that's the case, you can't ensure that that's the case, you as the employer have several legal outs available to you, which can run from, we're going to deny the accessibility support and try to find another accessibility support that might work instead, to I can change your job because you can't do this one anymore, to something called constructive dismissal. And so while the human rights principles are exactly the same, the way that these get applied in the context of school versus the context of employment are actually somewhat distinct, right? And I will also say at this point that by employment, I mean the university gives me a paycheck, right? Now, you can imagine a scenario where someone is a graduate student and part of their salary support comes from being a paid employee of the university because they're also a graduate teaching assistant. In this scenario, the accessibility supports that are provided by the school to the student are independent of the accessibility supports provided by the school to the student as an employee. And so what that basically means is if you are my graduate thesis supervisor and you're also the person who's hired me to teach your second year, molecular biology course, right? Then we actually have to have two separate conversations because there's two separate roles at play and two separate rules that have to that have to be minded. In the case of you as my thesis supervisor, I'm your student. But in the case of you as the course coordinator for the second year molecular biology course, I'm your employee.
But isn't that a duplication of effort?
Not necessarily, because you're my thesis supervisor. I'm a graduate student. The accessibility supports I might need are in the context of the research training environment, right? But you're my course coordinator for the second year molecular biology course that I'm teaching on your behalf, and the accessibility supports that I might need have to do with marking, have to do with classroom, not research training environment, right? So the settings are different, and even if the supports overlap to some degree, the way that it actually works out is that it's quite possible that the same person can actually have two different sets of accessibility supports in two different environments. Where it might be a duplication of effort is if that's a teaching lab, right? And so the things I might need to teach in a teaching lab might be very similar to the things I might need to conduct molecular biology in a research lab, right? That's one place where you might have functional overlap. I think where you're going at the duplication of effort is there's two offices suddenly involved in the provision of accommodations to one person, or the provision of accessibility supports to one person. Isn't it likely, and forgive me if I'm putting words in your mouth, but isn't it likely then that those two offices are going to work at cross purposes?
Yeah, or do the same thing.
Or do the same thing.
Or
yeah, and
do their own research and come up with the same answer. It just seems
they could.
Unnecessary.
They could, but it's actually really funny because the tuition of the graduate student will pay for the service, right, as a graduate student. But the moment I sign an employment contract with the university, not only am I paying tuition to the university, but I am also being paid by the university. So all of a sudden there's two legal relationships between us, right? And you are quite correct that that does tend to muddy the waters, right? And absolutely complicate the issue, right? So now let's talk about this a little bit more. Do you have a fair sense as to what a bona fide occupational requirement is, or would you like me to describe it for everyone who's watching?
I think you need to describe it.
Okay. All right. So a bona fide occupational requirement is a legal term. And effectively what it means is this is a thing that must necessarily be done in order for the job to be performed. And it has to be done in a specific manner, right? These are the kinds of things that in an ideal world are actually written clearly in job descriptions, right? So if I'm in a teaching lab and my responsibility is to, for example, dissect fetal pigs for bell ringer exercises, right? Because I'm that as a teaching assistant, that's part of the prep that I have to do. And now it's not molecular biology anymore. It's like, introductory biology or a basic physiology course. And so I've got to prep these fetal pigs, right? I need to dissect them and open them up and make sure they're available so we can point out heart, liver, lungs, all that fun stuff. And now that's written in my job description, specifically dissect fetal pigs, right? And because of the nature of the teaching lab, that's what I'm doing for 12 weeks, right? Every week I'm dissecting fetal pigs. You can make an argument as my employer that that is a critical task. That is a task that needs to be done in order to do the job. If somebody else is dissecting fetal pigs, then it doesn't make sense for me to be doing that job, right? That's the premise behind a bona fide occupational requirement. It's a thing that needs to be done for the performance of the job, and there's only so many ways to do it, right? Now, sometimes those bona fide occupational requirements can be discriminatory, right? And sometimes that discrimination is okay. So let's back away from the STEM example for a moment and imagine a scenario where you know, let's say, for example, how big is the Los Angeles Zoo? Is it big enough that you need golf carts to get around, or mini shuttle buses or something to get around?
There are golf carts, there are little shuttles. It's on a hill, so
Okay.
it's challenging to walk around.
Okay, so let's then say that the Los Angeles Zoo was hiring somebody to specifically be the driver of those little shuttles, and you needed a certain type of driver's license in order to do that legally, right? Now, let's say I love working at the zoo and I wanted to come in and keep you company on a regular basis and work at the zoo right alongside you, and I apply for the job. But obviously I don't have a driver's license of any kind, right? And so during the interview, they say, we need your driver's license. And I say, well, I don't have a driver's license. Here's my photo ID. This is proof of identity. This is who I am. And they say, no, 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 no. We need your driver's license because we need to know that you can drive. And me, not actually knowing what I know, but me could say something like, well, you can always provide an accessibility support, right? Somebody else can drive. I can be along to navigate, right? And they're going to say, well, no, because we need somebody to drive. We don't need somebody to navigate. We need somebody to drive because that's the essential requirement. That's the bona fide occupational requirement of the job, right? I could contest that. I could argue that. Odds are I'd probably lose the case, because at the end of the day, that bona fide occupational requirement, the requirements to be able to drive the golf carts to get around the Los Angeles Zoo, to be able to drive the mini shuttles to get around the Los Angeles Zoo, that is essential to the job. And if that cannot be done, right, no matter how you actually try to wrap an accessibility support around it, if that cannot be done, then I can't do the job, right? So that's a legitimately discriminatory bona fide occupational requirement. You are allowed to have those, but there is a legal test to make sure that those bona fide occupational requirements are legitimately discriminatory, right? And the legal test for this is something in Canada which is called the Meiorin test, and it comes from a case in British Columbia in the early 1990s, I think it was, when a woman who'd applied to be a firefighter had been rejected because of effectively gender biased sort of height and strength and size requirements, right? And the judge in the Human Rights Tribunal that took that case said, well, no, as long as this person can demonstrate that they can do this task, then they might do it differently than a man would, but they can still do the task. So you lose, BC Firefighting Organization, right? And that became a landmark case around what wasn't a legitimately discriminatory bona fide occupational requirement. And so this is one of the key concepts of duty to accommodate, and how an organization's responsibility around accommodation or accessibility supports plays out for employees, right? The threshold to achieve these kinds of barriers exists in the context of students, but they're usually much harder to get to unless you've got somebody in a professional program or in a graduate program who's trying to make a case that this accessibility support that somebody needs to do their job or so, that somebody needs to learn in school is simply not practical in the working world, at which point the university's lawyer will say, well, you can't actually make that argument. At least the lawyer worth their salt will say you can't actually make that argument, because you cannot say that the inability to provide this accessibility support, if this were a job, is a reason to not provide the accessibility support in school, right? And so in undergraduate education, especially in course-based programs, especially, the threshold of discriminatory, like the threshold to permit a discriminatory academic requirement is much higher than in, say, a professional program in graduate schools like nursing or medicine or engineering or STEM graduate school, right? And even that is higher than what you would find in the working world. And so this is the real difference between the organization's responsibility to its students versus the organization's responsibility to its employers. To its employees, because the responsibility to employees is much more about protecting the risk profile of the organization, and we'll come back to why that's the case in a moment. Whereas the responsibility to the student is to teach the student, right? And so that's student, that's employee, and where things get really messy is, well, you don't pay tuition, and you have third-party grant money that's paying your salary, and you may or may not be classified as an employee of the university. And so if you're a postdoc, where do you fit? Right? And at the time that these conversations had gone on in the late 2000s and early 2010s, when I was engaged much more heavily in the postdoc experience space, there was all sorts of conversations around benefit and pension and so on. What nobody was talking about were the conversations around accessibility supports, right? Because if you're my postdoc mentor and I'm a postdoc, you hire me to come work in your lab, and you're hiring me off of a grant to come work in your lab. There is a piece of paper that says that that I'm formally, for the sake of legal contractual obligations, the employee of a certain university. Pick your university of choice, right? And that's all fine and good. But then I say to you, Kate, you're my boss. I need to tell you these are the things I need to work inside a lab effectively. And you're going to say, oh my goodness, who's going to pay for all that? It's not in my grant budget. And then you go to the university, and the university will say, it's your responsibility. And you will say, no, legally, you're the employer, it's your responsibility. And then you and the university will get into something of a squabble. And the easiest way out of the squabble is to very quietly let the postdoc go. Or not have the postdoc come in the first place if you're actually still in the process of negotiation. Right? So it absolutely does matter which group we are talking about here, right? So I'm going to pause there. I want to unpack this a little bit more, but I'm going to pause there and give you the opportunity to reflect on what I just said.
Well, I guess very naively, I hadn't realized the differences. The postdoc one doesn't surprise me, because we had issues when postdocs went off and they were pregnant and they needed to go on maternity leave. So I've experienced issues with those. And also the fact that you could have two different departments kind of squabbling over the accommodations, or what did you call them? An accessibility support. That just seems, I'm all about efficiency. So I'm like, why isn't there just one person who is just like, and I'm going to help you and I'm going to do it? Like, in my mind, that's what should happen. So that's a little concerning. And you said this was North America. So are you talking Canada and America when you say North America?
So I'm talking about Canada and the United States. The rules in Europe are very similar. The human rights frameworks are very similar. In other parts of the world, I think and when I say that, I'm thinking like a, like a Brazil and India, China, and so on. The principles might be similar. The methods of execution might be a little bit different. I think a lot of it will depend on sort of what the local human rights frameworks actually are, because in most cases there isn't legislation that governs this. So in Australia, New Zealand, Canada, US, UK, Western Europe, this is basically the frame in which we're operating. Everywhere else, the human rights framework might be the same. The specific execution might be a little bit different.
So that was my next question, was, does it change depending on your country? So they're similar depending on where you are, but then in other countries it's going to be quite different. So I guess
so there's that, and I think part of the challenge, if you're an international graduate student or you're an international postdoc, you're accustomed to your country's rules. You're not accustomed to the rules in North America, right? And so how you actually navigate all of this is complicated because of a few things. One of them is a lack of familiarity with North American rules, but then the other is sort of this sort of basic idea that you also have cultural differences with respect to how disability is taken up from a conversational perspective, from a a point of view of contribution to society perspective, from the perspective of, if you're someone with a disability, are you even imagining that you can do a postdoc or do graduate studies in a different country, right? And so some of that might also be kind of what disability group you identify as belonging to, and how long you've lived with your lived experience, and whether you were born with it or whether you came into it prior to you started your graduate degree, or prior to you starting your postdoc, or you came into it during some aspect of your education that means that you're treating it differently, right? And so all of those things matter, and they matter in weird and wonderful and very complex ways. And they actually impact substantially sort of how one's career is going to spin out.
Yeah, I just think that if you're capable of doing the job, even if you do it in a slightly different way, then you should be able to do so. And
So
if that involves accommodations, then that should be fine. Like, if you're the best person for the job, they should be willing to work with you in order to allow that to happen. So in your case, if you need big print words, then that's what you get. If you are someone who is hard of hearing, then that accommodation is also put forward. If you have a support or an animal that helps you check your blood pressure, blood sugar levels, or whatever it is, then obviously the animal comes with you in a safe manner. Like, this doesn't seem challenging to me, but apparently it is.
So it is, and there's all sorts of wonderful reasons why. And if you want, we can get into those in the next video.
Okay. Does that mean we should wrap this one up?
Probably.
Okay. So I believe the next video will be why is DEI, or IDEA, relevant to science? So please join Mahadia and I when we go and dissect that. Thank you for joining us today. Please go back and watch the other videos. Please like and subscribe to both here and IDEA STEM. And I look forward to seeing you in the next one. Thank you. Bye-bye.